I'm Judge Elaine Gordon, and I'd like to welcome you to Case Flash, the Rules Edition, Part 1. In this section, we are going to discuss some of the practice book changes that went into effect on January 1st and March 1st of 2013. We've divided this into two parts. The first part is going to cover the changes to everything but the appellate rules, and we're going to highlight some of the most important changes because some of them are pretty straightforward and we don't want to take up too much of your time or your attention on these matters. And part 2, which will follow as a separate section, is going to take up the appellate rules. In both of the sections, I'm going to be joined by Ellen Palmer and Sam Schoonmaker, and let's turn to the beginning of the practice book changes and begin. Perhaps one of the first rules that we wanted to discuss was the new Rule 1.10, which has to do with the disqualification of lawyers when they, and firms, when a lawyer from one firm moves to another. And it has shifted the burden, basically, to saying that the conflict will not be imputed where a lawyer who is disqualified joins a new firm as a lateral hire when there's been a screening process that makes sure that fairness to the former client is preserved and gives that client an opportunity in court to challenge the screening process and have a hearing before the tribunal. Alan, did you want to say something about that one?
I think the two things that jump out at me from the changes to 1.10 are first, there's no real level of description of the word association in the rules. There's no differentiation between an associate who may be in a satellite office and an associate who actually works on the file and has confidential information at his or her disposal. The second thing that jumped out at me from the changes to this rule is that really the changes I don't necessarily think were absolutely necessary. The official commentary to 1.0 involving the screening process conspicuously left out Rule 1.9 and 1.10. That was always a distinction between Connecticut's rules of professional conduct and the model rules. I don't know why the Rules Committee simply didn't just amend the official commentary to 1.0 to include 1.9 and 1.10 within its purview. By creating this whole process, I think they've made it more confusing.
The other professional conduct rule that's been affected that we wanted to note was, well, there are actually two other ones. The House Counsel now can provide pro bono legal services, and I think this is important and will make all the people who are looking for pro bono help happy, because there had been some controversy in the past that in-house counsel were not necessarily practicing law within the state, or couldn't provide pro bono legal services, may not have been admitted, and may in fact not have been going into court, but may have been assisting with pro bono projects. And so I think this takes care of that rule. And the other one, which I think is interesting, is that lawyers can now participate in appropriate internet-based client-to-lawyer matching services. And I don't think those are dating services, are they, Sam?
I imagine that they're not.
I guess that this is going to allow for some more commercialization and some advertising for people who'll be able to go on national sites and beef up their practice that way. Just kind of going through some of the other rules. In the disciplinary section, 2.2-34A has been amended to allow the disciplinary counsel to add allegations of misconduct to grievance complaints. And, we do have statewide disciplinary counsel now, and I think that it gives them the opportunity to perhaps add allegations of misconduct, perhaps from patterns they've seen or other things. Sam, do you have anything you want to add to that one?
Well, I think as they look through a file, if something jumps out at them, they can sounds like they can mend their petitions and their complaints.
Right. And I think the other power that's been given to the statewide grievance committee or reviewing committee is that it can impose an audit on lawyers' trust accounts going forward without a respondent's consent. So for people who may have had a problem with the sanctity of their trust accounts, you can have a monitoring procedure in place, and you can have audits ordered into the future, which is something new. I think we've been able to audit going back, but not necessarily keep it as a tool. So I think that's helpful and certainly client friendly. And if we move on, there are a number of smaller rules. 3-8 eliminates the 10-day limit for a party or an attorney to object to being replaced by a new appearance. But in 3-9, the attorney whose appearance has been removed can file an appearance for the limited purpose of objecting to the in lieu of appearance. It makes me smile.
I don't know when that happens.
Have you ever had a situation where somebody objected to being replaced as counsel in the form of an objection?
No, they were usually relieved. But no, they have not. I've never seen one of those, so I'm not quite sure. It must come up, or they wanted to make clear that there may have been it may come up, and they wanted to give the lawyer the right to be able to do that. So it's there. We have again made clear that exhibits in 10-29 exhibits should not be attached to the complaint, but rather filed and served separate from the original complaint. I'm still not sure what the point of this is, because does this still mean that they're going into the file, exhibits?
As attached to motions, or what?
Well, to the complaint. Let's say you have a complaint and you have a contract, which we used to attach, and now it's not being attached, but it's going to be filed and served separate from the original complaint. So do we file it separately and serve it on the other person, but it's still in the file? Do we know?
What if there are other objections to the exhibit as to its admission, let alone filing in a public court file?
Well, the thing I was concerned about was that on a courtside trial, that certain exhibits may or may not come in. It's a problem in family cases, which we're all familiar with, where people have been attaching exhibits that maybe a better sense of discretion would have kept them from putting into a file, sometimes just to embarrass people or to make sure that they were seen by a judge who might not otherwise see them.
Right, usually attached to a motion of some
Right.
sort or an objection.
Right, so this rule 10-29 only deals with complaints. Is that true, Alan?
Pleading specifically, and the question we had was whether under Zarinsky an exhibit should be attached to a motion or can be attached to a motion. It would appear that on the face of 1029 that procedure would no longer be advisable. However, under Zarinsky, they do make a distinction between motions to modify and canned pleadings, which are defined in 10-6 of the pleadings section of the practice book.
Well, I know that we've been telling family lawyers for a long time to file motions to expunge, to get rid of those things. So even if they're allowed to continue to do this, I guess that avenue is still available for them. But it's certainly not the better practice. And similarly, in 13-4, parties are not to file their expert's written report when they're disclosing their expert. And they've also been told not to file disclosed medical records or medical reports with their expert opinion disclosure. And I think, interestingly, they're not supposed to file reports involving trade secrets. So I'm kind of dumbfounded a little bit that we still have to tell people not to file all of these things that you think common sense would tell you not to file.
Yeah, or the 13.4 disclosure will just have all the details from the report itself in the disclosure without even having the report as an attachment. So
Right.
That's going on anyway, too. I don't know if that necessarily is precluded by this rule. It's just something that unfortunately is happening.
Well, I'm sorry, go ahead.
Other than expungement, what other remedies might be available to a party for a violation of 13.4 or 10-29 or 4.7 or any of these other administrative changes that they've made? And what if the expert report, including trade secrets, is disclosed with the disclosure of expert? What's the remedy?
Well, I think
Is there a
that's,
sanction? Is there, other than expungement, what really do we have to go for at this point?
don't you have the same sanctions that are available for all attorney bad conduct? Other than that, do you really, the practice book doesn't have anything in it to tell you what to do about it.
Of course, in that case, you're focusing on the bad document that was attached to the pleading, so it's a double-edged sword in a lot of ways.
Right, right. And I think Sam's point is also good. This says you're not supposed to file the expert's written report with the court, but so often the disclosure now is in fact just a cut and paste job from the written report, which has happened because people felt that they needed to put that in because they were getting faced at trial with saying that their disclosure had been inadequate and didn't have enough detail to it. So there is a kind of tension between those two things. So,
Well, under the old Rule 220D, before they started playing with the rules, we used to simply reference in the disclosure of expert, please see report attached.
right,
And you can't do that anymore.
right, which leads to the cutting and pasting.
Yep.
25-60A clarifies in family cases the court authority over private evaluations that are done in custody, visitation, and access cases. And those are cases where people hire outside evaluators, right, instead of using the family services office and family relations officers to conduct the studies. You saw an anomaly in that, didn't you?
Yes.
Or an anomaly even?
What the Rules Committee did is they added the word private in the title and in front of the word evaluation in subsection A. They left subsection C intact without making the same change, and it would appear that in subsection C it would still be possible, it would appear from subsection C that you can no longer contact the family relations officer who might be assigned, since they're not a private evaluator. They would appear to now be subject to inquiries from counsel for the parties after this rule change. However, sub C would appear to put an end to that. Because sub C is included in a section devoted exclusively to private evaluators, the question is whether sub C would apply to family services or not. And there's no cases thus far on the issue.
Right, so they were trying to make clear that private evaluators aren't supposed to be contacted, that they can initiate contact, but people shouldn't be lobbying them. And what you're concerned about, I guess, is that it maybe is an oversight. They've left out the family relations officers.
That's what I think.
Well, I'm sure Judge Monroe, if that's the case, will take care of it. Right?